Another hot topic of debate and discussion in the Indian political and legal sphere is the places of worship. Special Provisions Act 1991. So, exactly what is the object of the Act as it was enacted in 1991? The Act to prohibit conversion of any place of worship and to provide for the maintenance of the religious character of any place of worship as it existed on the 15th day of August 1947 and for the matters connected therewith or incidental thereto, and the very provisions of the Act that we would like to discuss. In that regards, the Supreme Court of India has adjourned the very case relating to the Places of Worship Act relating to the validity of the Process of Worship Act of 1991, allowing the Centre until October 31st, 2023 to clarify its stance on the matter. So the very act enacted to freeze the status of religious places of worship as they existed on August 15, 1947 and prohibits the conversion of any places of worship and ensure the maintenance of their religious character. So, the very important provisions that we found under the Places of Worship Special Provision Act 1991 as per the provisions of Section 3, it prohibits of conversion. So it prevents the conversion of a place of worship, whether in full or part from one religious denomination to another within the same denomination. And as regarding Section 4, subsection 1, it provides maintenance of religious character. So it ensures that the religious identity of a place of worship remains the same as it was on 15th August 1947. And subsection 2 of Section 4 provides regarding abatement of pending cases. It declares that any ongoing legal proceedings concerning the conversion of a place of worship's religious character before 15th August 1947 will be terminated and no new cases can be initiated. As per the provisions under Section 5 relating to certain exception to the Act under Section 5 does not apply to ancient and historical monuments, archaeological sites, and remains covered by the Ancient Monuments and Archaeological Sites and Remains Act 1958. It also excludes cases that have already been settled or resolved and disputes that have been resolved by mutual agreement of conversions that occurred before the Act came into effect. So also, the Act does not extend, as per the provisions of Section 5, to specific places of worship known as Ram Janmabhoomi, Babri Masjid in Ayodhya, including any legal proceedings associated with. And finally, Section 6 of the Act provides regarding penalties. It specifies penalties including a maximum imprisonment for a term of 3 years and fines, and for violating the Act. So, in that context, we would like to discuss certain important leading judgments and legal cases as under the background and also of constitutional provisions. So specifically, in September 1991, when Parliament passed the Places of Worship Act 1991, the law was passed with the object of prohibiting conversion of any place of worship and to provide for the maintenance of the religious character of any place of worship as it existed on 15th August 1947. The act came under challenge when the Supreme Court was adjudicating a property dispute on the site where the Babri Masjid once stood. The mosque was vandalized and razed by a mob of car sevaks, religious volunteers on 6th December 1992 on 9th November 2019. A five-judge constitution bench unanimously awarded the title in a disputed property to the Hindu deity Sri Ram. The decision closed the files on a 450-year-old dispute. In that case, the court upheld the validity of the Places of Worship Act 1991. It noted the Places of Worship Act is intrinsically related to the obligations of a secular state. It reflects the commitment of India to the equality of all religions. And on October 2020, one Ashwini Kumar Upadhyay, an advocate and a former spokesperson for the Delhi unit of the Bharatiya Janata Party, filed a petition challenging the constitutional validity of Section 2, Section 3, and Section 4 of the Religious Places of Worship Act 1991. Section 2 of the Act defines commencement of this Act as commencement from July 11, 1991, conversion as alteration or change of whatever nature and place of worship as temples, mosques, gurudwaras, churches, monasteries, places of worship of religious denominations or other similar places. While Section 3 criminalizes conversion of a place of worship for one religion or sect into another. As well, Section 4 declares that the character of a place of worship will be determined as it was on 15th August 1947. It also bars courts from determining whether any place of worship has been converted after 15th August 1947. And Section 5 states that the act was not applicable on the site known as Ram Janmabhoomi or Babri Masjid, the site which was awarded to Sri Ram. Janmabhoomi in 2019, the petition argued that the act bars judicial review because Section 4 prevents the courts from adjudicating in particular cases. Moreover, it pointed out that the power of judicial review is a part of the basic structure of the Constitution and cannot be taken away. They claimed that it also violated principle of secularism, multiple interventions. The petition implied that the act showed preference to one religious community. The petition contained from 1192 onwards Muslim and British ruled India and destroyed temples by preaching the dead in 1947. Hindus, Sikhs, Jains, and Buddhists were prohibited from resorting their places of worship. This violates the right to equality and non-discrimination as provided under Article 14 and Article 15 of the Constitution of India. It also contended that the Act violates the right to life as provided under Article 21 of the Constitution, since the law violated the right to justice, right to judicial remedy, and right to dignity. The petition stated that the law violates the right to religious freedoms as recognized and provided under Article 25, 26, and 29 of the Constitution of India. Citing Hindu laws, the petitioner argued that destroyed temples are still temples in the eyes of law, as deities are eternal and they do not lose their ownership over land once their idols are destroyed. Islamic laws require a work to acquire a mosque. Destruction of temples does not create a work and is not a valid mosque in Islamic law. So on 12th March 2021, a division bench led by the then Chief Justice of India, Ranjan Gogoi, issued notice in the matter. In May 2022, during a hearing on allowing survey of the Ganavapye Masjid in Varanasi, Justice D.Y. Chandrachud noted that ascertaining the religious character of a place of worship was not barred by the act. Therefore, while the religious character of a place of worship can be determined, it cannot be converted. So in November 2024, also deadly violence erupted in Sambhal in Uttar Pradesh after a district court ordered a survey of the Shahi Jama Masjid located there. Shortly after, another district court issued notice in a civil suit claiming the existence of a Hindu temple under the Dargah of Sufi saint Mainuddin Chishti in Ajmer. Also on 6 December 2024, after a district court directed registration of a suit disputing the existence of a Hindu temple under the Atla Mosque in Jaunpur, the mosque committee challenged the same in Allahabad High Court. So on December 2024, Chief Justice of India, Justice Sanjeev Khanna, formed a special bench consisting of Justice P.V. Sanjay Kumar and Justice K.V. Vishwanathan to hear the petition. The challenge was listed and it would be heard and as per the decision of 2024. Subsequent multiple intervention applications were filed by retired bureaucrats, members of parliament, and the Indian Union of Muslim League Management Committee of Shahi Masjid Idgah in Mathura and the All India Lawyers Union, among others, in favor of upholding and seeking enforcement of the Act. So finally, on 12 December 2024, the special bench, as constituted by the Chief Justice of India, Justice Sanjeev Khanna, stayed registration of any further suits demanding surveys of places of worship until the next date of hearing. It provided 4 weeks to the Union to file a counter affidavit and appointed nodal counsels in the case. So, now we would like to discuss those criticisms were forwarded against the Places of Worship Act and those criticisms that exactly we found on bar on judicial review. Critics argue that the act prevents judicial review, which is a fundamental or the basic structure of the Constitution as it was enunciated in the Keswananda Bharati versus State of Kerala in 1973, which constitutional bench framed the very basic structure of the Constitution. They believe this restriction undermines the check and balances system and limits the judiciary's role in protecting constitutional rights. And another criticism leveled against the Places of Worship Act 1991 is regarding the arbitrary retrospective cutoff date. The Act is criticized for using an arbitrary date, which is exactly Independence Day of 1947, to determine the status of religious places. Opponents argue that this cutoff date disregards historical injustices and denies redressal for encroachments before that date. And another major criticism labeled against the Places of Worship Act is relating to violation of the right to religion. So the critics claim that the act infringes upon the religious rights of Hindus, Jains, Buddhists, and Sikhs. They also argue that it restricts their ability to reclaim and restore their places of worship, impeding their freedom to practice their religion. Another important criticism labeled against the act is violation of secularism. Opponents argue that the act violates the principle of secularism, which is a core component of the Constitution, and it is also the basic structure of the Constitution and favors only one community over others. They also contended that this undermines the equal treatment of religions under the law. And another important criticism against the act is regarding exclusion of Ayodhya dispute. The act is specifically criticized for excluding the land involved in Ayodhya dispute, as specifically provided under Section 5 of the Religious Places of Worship Act 1991. Also, opponent questions its consistency and raise concerns about the differential treatment of religious sites. And finally, the Supreme Court stands on the act. So the Supreme Court views the Places of Worship Act as a legislative intervention that upholds the commitment to secularism, the fundamental aspect of the Indian Constitution. The Act also enforces the constitutional obligation of the state to ensure equality among all religions. It guarantees the preservation of places of worship for every religious community. And finally, we would like to discuss certain key suggestions that would enable the act to be properly implemented and carried out without any opposition or without any hindrance. So, those suggestions we could discuss to undertake a thorough review of the Places of Worship Act of 1991 to address all those criticisms and shortcomings that already we have discussed just now. And also, another important suggestion we could discuss regarding it would ensure the Act does not restrict judicial review, as preserving the judiciary's role in upholding constitutional rights, as judicial review is itself a part of the basic structure of the Constitution of India. Further, another suggestion that we would like to discuss that it would strike a balance between preserving religious character and respecting the rights of different communities. And finally, we would like to discuss another important suggestion, and that is it would involve public consultation, and it would ensure transparency and review the exclusion of specific sites to promote fairness and consistency. So, these are the important suggestions that we would like to discuss. And finally, some other developments that we would like to discuss, as exactly in 2019 the Supreme Court 5 Judge Constitution Bench made the following observation, which weakened the Act. Historical wrongs cannot be remediated by the people taking the law into their hands. In 2021, the Supreme Court judgment had impacts on the Places of Worship Act. So in 2022, the division bench of the Supreme Court of India, led by the then Chief Justice of India, Dr. D.Y. Chandrachud, accepted a petition challenging the constitutional validity of the Places of Worship Special Provisions Act 1991. And on November 14, 2022, a bench headed by the Chief Justice and Justice J.V. Padiwala gave the Solicitor General Tushar Mehta more time to file an affidavit, and as it clubbed together petitions filed by several people, including former BJP MP Subramaniam Swamy and advocate Ashwini Upadhyay, who had filed his plea on March 12, 2021. And regarding that, already we have discussed the provisions made in that regard, as in 2024, the Chief Justice of India, Justice Sanjeev Khanna, formed a special bench consisting of Justice P.V. Sanjay Kumar and Justice A.V. Vishwanath to hear all the petitions. So, these were listed for 12 December 2024. So, the special bench constituted by Chief Justice of India, Justice Sanjeev Khanna, stayed registration of any further suits demanding surveys of places of worship until the next date of hearing. It provided 4 weeks to the Union government to file a counter affidavit and appointed nodal counsels in this particular case. So, in detail, we have discussed the Religious Places of Worship Special Provision Act 1991, the very object behind enacting the Act by the Parliament of India, and those important provisions of the Act as laid down under Section 3, Section 4, Section 5 and Section 6 of the Act, and exclusively the provisions containing Section 5 of the Act, excluding the Ram Janmabhoomi and Babri Masjid site. And also we have discussed certain legal backgrounds and legal cases with the landmark judgments and the constitutional provisions as provided under Article 14 and Article 15 of the Constitution regarding right to equality and regarding discrimination, and also the provisions relating to Article 21, right to life, and also those religious freedoms granted as fundamental rights under Part 3 of the Constitution, under Article 25, 26, 27, and 28 of the Constitution. And besides that, we have discussed some important landmark cases as relating to Ganavapye Masjid in Varanasi, Shahi Jama Masjid at Sambhal in Uttar Pradesh, also the Atla Mosque in Jaunpur, also the Ajmer Dargah. And finally, we discuss about those criticisms laid against the Act and also the key suggestions made to implement without any opposition of the Act, and that is the religious places of worship, Special Provisions Act 1991.